The admissibility of relevant evidence. The general rule is that all relevant evidence is admissible. The exception is where a specific rule, such as hearsay, keeps it out. In fact, only relevant evidence is admissible. If the evidence is not relevant, it's inadmissible. The federal rules define evidence as relevant when it has any tendency to make the existence of any fact that's of consequence to the determination of the action more probable or less probable. There must be a logical connection between the evidence and the facts determining the outcome of the case. However, the threshold here is very low. No single piece of evidence is required to prove the case, or tip the scales to such an extent that it makes the existence of the fact more likely than not. The piece of evidence is relevant if it tips the scales, even very slightly. Conditional relevancy is where the relevancy of the evidence depends on fulfillment of a condition or fact. The evidence is not relevant standing alone, but becomes relevant when a condition or fact is met. How do we know when the condition is met? The courts use a reasonable jury preponderance of the evidence test. Could a reasonable jury find by preponderance of the evidence that it's more likely than not that the condition will be fulfilled? As an example, evidence that a child was fathered by another man is only relevant if the husband accused of murdering the wife was informed or suspected that the child was not his own. If the accused husband was not aware or suspected this, the evidence is not relevant to this murder case. If a reasonable jury could be persuaded by a preponderance of the evidence that the accused husband knew or suspected the child was not his own, then the condition is met and the evidence becomes relevant. If the condition is not met, but the evidence is presented, the judge orders the jury to disregard this piece of information. Not all relevant evidence is admitted to court. The court has discretion to exclude evidence that is logically relevant. The relevancy is essentially trumped by other rules of evidence. Evidence may be excluded on grounds that it's unduly prejudicial, misleading, privileged, hearsay, character evidence, and so on. Evidence that may be relevant is sometimes locked away, as its probative value is outweighed by other concerns. Some evidence, although relevant, is inadmissible at the discretion of the judge on grounds of prejudice, confusion, or waste of time. Cases involving murder, rape, assault and battery often involve gruesome photographs of the victim, the weapons and the crime scene. These photographs can have probative value, but they can also create a risk of unfair prejudice. The judge has to weigh these two factors, the probative value versus the risk of unfair prejudice, when assessing whether to admit a gruesome photograph. Often the judge in a murder trial will allow a sample of pictures showing the murder victim's corpse, but not a large number, as this could easily cloud the vision of the jury. The risk of unfair prejudice must substantially outweigh probative value to render evidence inadmissible. Should evidence of similar happenings be admissible in court? They may not be dealing with the specific case in hand, but evidence of independent similar happenings is sometimes admitted. There's no federal rule to address this, and the admissibility is determined under the discretionary powers of the judge. In a product liability case resulting from a sinking boat, the plaintiff may want to introduce evidence that the same model of boat has been known to sink in other instances. The judge assesses whether the probative value of the evidence outweighs countervailing concerns and looks into whether the circumstances of the other boat sinkings were substantially similar. If the case at hand concerns a boat sinking in still water, and the evidence proposed by the plaintiff concerns boats sinking in heavy storms, the circumstances are not substantially similar, and the evidence of the other boat sinkings will likely be ruled inadmissible by the judge. By the same token, a defendant in a case may wish to introduce evidence that the event has never happened before. Again, the judge weighs the probative value and looks to whether the circumstances are substantially similar before deciding to allow the evidence to reach the jury. In short, similar happenings evidence is only admissible when the circumstances are substantially similar. Whether the accused burglar was able to physically climb through the window may be demonstrated to the jury by reenacting the scene using an actor and a model window in the courtroom. However, the circumstances must be substantially similar to the event in question. If the model window is significantly larger than the one burgled and the act is significantly smaller than the accused, the reenactment may be misleading and inadmissible. In these situations, the judge determines if the risk of unfair prejudice substantially outweighs the probative value of the reenactment. In a famous case from the 1960s, the Supreme Court of California set aside convictions after the jury at trial found the defendant guilty of robbery, based on a mathematical argument that the probability of the defendants matching the witness reports of a black man with a mustache, a white woman with blonde hair, fleeing the scene in a yellow car was statistically very high. In the absence of other evidence that the defendants were at the scene, the guilty verdict was set aside. Mathematics can be used to assist the jury to find the truth, but is inadmissible when it's misleading, inaccurate, confusing, and relied upon too heavily. In this famous case, the statistics were inaccurate, misused, and misleading. However, when used properly, evidence based on probability and mathematics can be valuable to the jury and is often ruled admissible. Relevant evidence is inadmissible under certain specific rules on the grounds of public policy. As we will see, there are certain types of evidence that could be harmful to the public if allowed in court. It's in the safety interests of the public for dangerous problems to be fixed. However, the plaintiff may wish to use this evidence to show culpability, arguing the problem must have existed as they fixed it immediately after the accident. The rule is that the evidence of subsequent remedial measures made by a party to the case is inadmissible if offered to show culpability or negligence. The exception, allowing this evidence into court, usually with a limiting instruction, is where the evidence is offered to show something other than culpability or negligence. For example, the fact that the defendant fixed the problem can be admitted to show ownership. The plaintiff may argue, he claims he didn't own it, so why did he fix it? This may be admitted with a limiting instruction by the judge, instructing the jury to use this evidence to show ownership but not culpability. It's in the public interest and the interests of the judicial system for parties to settle disputes out of court, and would discourage settlement if one side used evidence of settlement offers to help prove the validity of the claim. She offered to pay me to settle may be relevant in that it goes to show she had a guilty conscience. But settlement offers are inadmissible when presented to prove the validity of the claim or the amount of damages. This holds true regardless of whether the offer was accepted or rejected. Settlement offers can be admissible, though, when presented for another purpose. A settlement offer that's inadmissible to prove validity of the claim may be admitted when it's used to explain a delay in the legal process. The legal filing was delayed as we were trying to settle out of court. Where the validity and amount of the claim is accepted by both sides, evidence of an offer of settlement can be admitted. For example, where the defendant says, I acknowledge I owe you $20,000, but it will cost you $20,000 in legal fees to take this to court, so I offer you $5,000 in settlement. It's in the public interest to discourage blackmail of this sort, and this type of offer is generally admissible. She offered to pay my medical expenses. This is inadmissible evidence on public policy grounds that we don't want to discourage payment of medical fees. However, other statements made at the same time can be admitted as evidence. For example, she said she was distracted by texting on her phone at the time of the accident. She admitted causing the crash and offered to pay my medical expenses. This would be admissible. In criminal cases, it's in the interests of the public to encourage plea bargaining, so evidence that the accused offered to plead guilty is inadmissible on grounds of public policy. A guilty plea that's later withdrawn, statements made during plea negotiations, statements made during court plea proceedings, and a plea of no contest are all inadmissible in the criminal trial. However, a plea of no contest in a criminal trial may be admissible in a subsequent civil trial. The general rule is that evidence of liability insurance is prejudicial and inadmissible. The jury may be swayed by the argument, "Don't worry, his insurance will pay the damages anyway." However, liability insurance is in the interests of the public, and we don't want to discourage members of the public taking insurance policies to cover themselves and people they may injure. There are a couple of exceptions to the rule that evidence of liability insurance is inadmissible. It may be admitted for another purpose, such as to settle a dispute over ownership. If he didn't own it, why did he insure it? When a party disputes ownership of property, evidence of insurance can be used to prove ownership or control. Of course, an insurer that's set to lose financially from the case would make a biased witness. So in another exception, evidence of insurance can be introduced to show bias or motive.